So in my other world, I've been a professional jazz pianist and music educator for a long time. And this is the tune that I mentioned earlier, and it's about a couple of minutes. It's a short version of a jazz tune because a long version of a jazz tune would take up all of our time. Yeah, so that was called Tango para Maria Luisa, and I wrote that for my Aunt Mary Lou.
That is wonderful. Thank you for sharing that. I really appreciate it. We've got a recording of your session from the practice law session too. We can share in the practice law community for those of you who want to see more of that. I want to welcome everyone to this morning's session of Business as Usual. I have to, before I forget, thank you to our sponsor, Olson Thielen. They are sponsoring this morning's broadcast. Olson Thielen assists legal firms with tax, audit, and advisory services. They invite you to view their video gallery of business and personal finance topics. More at otcpas.com. As I was telling Lawrence earlier, they did some great presentations for us at the Practice Law Conference last month. And again, that was another great presentation. But let's chat about where we're at. I want to welcome our guests. Lawrence, why don't you tell us a little bit about yourself and about I'm also curious to know about the organization you just started working for. Can you tell us a little bit about that?
Right. So again, I'm the old guy in the room. I've been practicing 37 years. Before that, I majored in music at the U, was a high school band director and kind of a working nightclub musician, which is a whole nother story of that life. And then went to law school to do public interest work. And I've been doing that essentially my whole career. So about 30 years at various legal aid programs around the state, central Minnesota and in the Twin Cities. And then 7 years pro bono counsel at Dorsey and Whitney, kind of running kind of their pro bono litigation program there. And then got laid off from there in the spring. Dorsey, like a lot of firms, was looking at cutting back, and so they cut back on their pro bono program. And so then the summer, I live, my wife and I live frugally, and so we were not real stressed over the situation. And I actually used the summer to learn a little bit about music technology that I didn't already know. So that last clip that you saw, I've learned video editing, and I've learned streaming software and remote performance software. So I kind of used that time well. And then I started this fall with the Lawyers Committee for Civil Rights Under Law. For those of you that don't know that group, it kind of has an unfortunately vague name. Sometimes when lawyers name things, they think a little too functionally and not descriptive enough. Like, think of all the types of cases that are based on sections of laws rather than what the laws actually say. So this is one of those groups. If you don't know anything about it, it's kind of like the ACLU. It's a Washington-based group, but it has people working in different parts of the country. They received some anonymous funding to beef up their work in the housing area during the pandemic. And so they looked to have presence in a few states around the country, and they chose Minnesota because they were familiar with my work here and knew that I was in between jobs. So I started with them on September, and my job is to help really train and mentor and co-counsel with attorneys and law students around the state to really beef up the ranks of people that are doing this kind of work. There aren't a lot of evictions going through the system right now because of one of the governor's executive orders, which really slowed down most evictions with a few exceptions. And so the legal aid world and volunteer attorneys are able to keep up with them at this point. But I can talk in more detail, and I even have a slideshow that I could use if it's appropriate to get into that at some point, that talks more specifically about what the numbers might be. And I think it's fair to say that you can call it a tsunami or a flood or a hurricane or whatever you want. But whenever evictions open up without limitation, there's going to be a lot of demand for help from pro bono attorneys, because legal aid staffs they're stagnant. It's not like they're going to expand 2-3-fold when this happens. So they'll be locked into their staffing patterns, and it's really up to the private bar to roll up their sleeves and jump in. And this is doable work. You don't have to be an encyclopedia of this law like I am to do it. You need to learn kind of the silos that are relevant to the cases that you do.
That's great. And I do want to get into how folks can get involved and what they need to learn, what steps might be taken to get up to speed, for folks like myself who only have ancillary relationship with landlord-tenant law, especially, or real property law altogether. But yeah, let's start. And if you want to wait, I can stop my share again. And if you've got a slide presentation, yeah, you're absolutely welcome to share that.
And I can jump through that pretty fast. I could
Sure.
probably get through that in about 15 minutes or so.
That sounds great. Yeah, I'd love to learn. I was sort of reviewing ahead of time here and looking at some of the numbers, but rather than me guessing, I'd love to have you share that information. There are a number of websites out there calculating the risk, interestingly, from how much it costs a state, for example, to usher folks into various public services as a result of evictions, the percentage of people who are at risk.
Yep.
And so one of my questions is, I know this is a constantly moving goalpost. Excuse me, but we had talked about the governor kind of putting a delay on the evictions at this point in time. Where's that goalpost at this point in time? How long do people have before, if there's no change, we're looking at what I assume is going to be a tsunami?
Yep. Okay, so that's a timely question. So why don't I just share the screen here and go through this slideshow, and I'll go through it pretty quickly. Let's see. Okay. So I first presented this last month to a funding group for legal aid programs to kind of get them thinking about possibly upping their resources in the legal aid world. So this has my contact information on it. And again, if you want to find any of what I've got here today, I have a website here for a class that I teach at the U. It's called Poverty Law. If you were to Google my name and poverty law, this will come up pretty fast. This is a lot of people use this website for their own research. And if you came to the homepage on the website, then you just go down to housing law and it pulls up this page, and I've got a menu here. And the slideshow I've got is on this pandemic eviction page, and it's a slideshow here that's talking about pandemic eviction estimates. I also have a more detailed slideshow on actually providing representational work in this area, and that's this one up here. And then I have an eviction defense manual, and that's more of an encyclopedia of eviction defense that you use more when you're trying to figure out specific litigation points in a case, because that's about 650 pages long, something like that. Okay, so so getting to your question, Landon, kind of what's going on right now. Well, you probably heard about the executive order here, and you may have heard about the CARES Act, and the CDC has a suspension order. The latter two are less relevant here. What's really at play right now is the executive order, and I'll explain that in just a moment. So the executive order has been in effect since March 24. It doesn't have a termination date, and it kind of rests on the shoulders of the peacetime emergencies. And those go at a month at a time. The current one goes until November 12. And then the same kind of song and dance happens each time where the governor says, I want to extend it. He calls the legislature back into session. The Republican Senate says no. Democratic House says yes. They wash each other out. And then he has another month of a peacetime emergency. Every time he does that, by cross-reference, the executive order extends for another month. So what's problematic about this process is that people don't know for sure a month down the road where are we going to be. I think it's a pretty fair estimate that these peacetime emergencies and this executive order's governance aren't going anywhere. When you look at the numbers in Minnesota, they're not as bad as our neighboring states, but it's not a pretty picture. And so having this in place, it may change a little bit, but I'd be surprised if it goes anywhere before the end of this year. And I'll explain that in just a moment. So there are exceptions to the eviction suspension. The main thing it does is stops evictions for non-payment of rent. And those are by far the most, probably 90% of evictions are for non-payment of rent. It doesn't change rent liability. So tenants still owe rent, they still owe late fees, but eviction's not a remedy. There's several exceptions to it. The main ones are if the tenant violates 504B.171, which regulates certain types of illegal and criminal activity on the property, most notably drug offenses, domestic violence, prostitution, and firearms are the main coverage of 504B.171. If tenants seriously endanger other residents, and this is where the language gets a little bit complicated. Also, if tenants seriously endanger people other than residents, if that's governed by the lease. So if you seriously endanger another resident, whether it's governed by the lease or not, that's an exception to this executive order. But if you seriously endanger people other than residents, then it would have to also be governed by the lease. If a tenant significantly damages property, if that's governed by the lease. And probably the weirdest one that's kind of, we haven't seen much litigation on it yet, is if the landlord gives a notice to the tenant saying, I want you to move because I want to move onto the property, or I want a family member to move on the property. That's always tough to advise a tenant on because the tenant doesn't know for sure if the landlord's being legit about it. Because you don't really know until after you would move out if the person who moved in was actually the landlord or a family member. And so that's kind of a tough one for a tenant to decide, do I want to stay and fight this or not? The executive order also requires, in all cases, a written notice of 7 days before filing a case to tip the tenant off that they are filing, because that might engage a conversation in which they settle the case and there is no case, or the tenant leaves and there is no case. All right. So what about the CARES Act? You might have heard about that. And you might think, though, the CARES Act, isn't around anymore because the unemployment benefits stopped under it. Well, there is a provision of it that did not have an expiration date, and that's the requirement that owners of what are called federally covered properties have to give a 1-month eviction notice. So that would be different than the 7-day notice I just explained. Okay? And what are federally covered properties? Part of this is fairly easy for those of us in the housing community to figure out. Federal, public, and subsidized housing programs. There's a big list of them, and we all know what they are. And usually tenants know if they're in that type of subsidized housing. What's more problematic are properties that have federally backed mortgages, like Fannie Mae, Freddie Mac, FHA. I own a home. That's where you see me here. I have no idea if my mortgage is federally backed or not. I'd have to go take a look at the papers to see. Now, it doesn't matter because I'm not a landlord, but if I were a landlord and I wanted to file an eviction case because I think someone is seriously endangering another resident, I would need to figure out through my documents, do I have a federally backed mortgage? Because if I do, then I have to give a 30-day notice rather than a 7-day notice. Now, to make this all even more interesting, on September 2nd, the CDC issued an eviction suspension order. And that took all of us in the housing community by surprise. We really didn't see the CDC as being a player in this world. And there was no tip-off that there was even any consideration going on here of this. The CDC, for health purposes, said we need to stop non-payment of rent evictions statewide or for countrywide. And there are a lot of states that didn't have executive orders like we have here. So this was a really broad thing nationally. It's broader than the CARES Act because it goes beyond federally covered properties. And so it spawned some litigation as to whether this was an overreach by the CDC to stop evictions of non-federally covered properties throughout the country. Those are churning around right now. And my last check, there have been no adverse decisions to the order, but some of those cases are still moving slowly. Its impact in Minnesota is really pretty minimal because it only applies where you don't have a state order that's more protective. And we do have a state order that's more protective. So its application here, except maybe just on the margins, I think is really kind of minimal. So there are financial assistance programs out for tenants. I've listed a few of them here. There's money from the CARES Act that went into state coffers, and there's money from that has been allocated to various counties. And so I just listed a few of the links where people can look to get that. There also are nonprofits that have money to help tenants out as well. Because again, the executive order does not stop liability for rent. It just stops the eviction remedy. And so it's certainly not going to be great for a tenant to have 7 or 8 months of rent liability parked up whenever evictions start going again. So what's going to happen when Executive Order 2079 ends? Depends a little bit on when that happens. But whenever it happens, what will be in place? Well, we'll still, for federally covered properties, you'll still have the 30-day notice before filing cases. If 2079 ends before the CDC order and the CDC order ends December 31, then the CDC order would be relevant in Minnesota and would step into the place of 2079. A little less protective, there are more exceptions to it, but conceptually they're fairly similar. There are some more procedural requirements to the CDC order. So like the tenant has to sign a declaration that covers a number of points to be covered by it, and their income is capped off while the state executive order isn't. Now, because the CDC order goes till December 31, I think it's unlikely that the governor would end 2079 before then, especially given where our numbers are right now. Now, we don't know the result of the election yet, and we don't know what the CDC is going to do on January 1. So there are just a lot of ifs in there. Other things that most lawyers that litigate know is that the judicial branch has issued a number of orders, both statewide and locally, making hearings more remote for health purposes. And that's good, but there are a lot of low-income folks that don't have internet access, don't have computers, can't go to a public library that's closed now to use public access. Access to the library at the court system is also limited as well. So for folks that don't have internet access, the court needs to accommodate them and provide some mechanism to allow for their participation. The last remnant that'll be sitting around here at least until February 15 is one of the session laws from the summer allowed the courts to play around with deadlines that were created by statutes. And so where I think that's relevant in the housing area is it gives the courts the ability to slow cases down, to not move them as quickly as they normally would, because the state statutes have a fairly defined time process for the adjudication of eviction cases, and this allows the courts to soften that a little bit. So what's the tsunami? And now we're just going to be playing a little bit in the estimate world because no one knows when evictions are going to open up and kind of what's going to be the backlog. So all we can do is kind of rough this out a little bit. 16,000 evictions a year in 2017, or about 1,300 a month statewide. When you look locally, about 6,000 statewide. From Hennepin County, about 3,000. From Minneapolis, Anoka had about 1,000. And so you can break that down on a monthly basis. And so a very rough calculation would be that if evictions open up in January, they would have been on hold for about 8 months. So you could take 8 times those numbers and come up with a rough estimate, okay? And that's a lot, okay? That would be a lot to have, 720 cases in Anoka County when they're, used to, about 90 a month, right? Now, that's a very rough estimate because some tenants may have moved. They may have negotiated with their landlords to reduce the rent. They may have gotten some rent assistance, so maybe that number is lower. But that ignores the economy. So now we need to talk a little bit about the economy. Unemployment's really high here. It's down from where it was higher in May, but it's still twice what it was before the pandemic. And another way to look at unemployment is to look at the cumulative applicants over the period of pandemic. So that tells you not who's unemployed right now, but who's been unemployed at some point during the pandemic. And when you compare that with what the labor force was in 2019, we see that basically anywhere from 1/3 to 2/3 of the labor force applied for unemployment at some point in the last 6 or 7 months. And that's big. So that's a big indicator of how many people may have gotten behind on rent in the last 6 months because they might not be unemployed now, but they were unemployed then and they haven't been able to catch up yet. So there are a number of stats about unemployment of tenants around the country that think that it's probably way higher than the general unemployment rate because people in the service community that are most likely to have been unemployed are more likely to be renters than homeowners. And so there's some analysis of this around the country thinking that maybe those figures are going to be up in the 20s or so. And so I'm just going to kind of roll past some of those figures here. So unemployment in Minnesota, the Census Bureau has been doing, and they're in the news a bit, and a lot of people have been complaining about, efforts to limit their work. But they have been doing, the staff has been doing something really cool in this pandemic. And they've been doing a survey every week called a pulse survey to just try to figure out how people are doing. And you might say the sample size isn't huge. 700,000 in our state is, a small number of the residents of our state. But still, it's a big enough number where I think you can draw some conclusions. And I think it's stark that in the survey, about 37% had an adult tenant unemployed in a tenant household. Okay, that's staggering. And 50% were reporting some loss of income in this period. And I've got links so you can look at all this stuff because this is based on the one issued on October 21, and these come out every couple of weeks or so. Some other information we've got, the percent of occupied units paying more than 30% of income for rent. So basically we're talking people that are paying a lot of money of their income for rent. Roughly around the state, about half. So about half the tenants are what we call rent burden. They're living on the edge of kind of being economically self-sufficient. And and so I'm going to skip by some of the national stuff here. And if you want to dig into some of this stuff, because I think there's information that really can be gleaned to a lot of different areas of practice. I've got links here to the census survey in the housing area. They look at a lot of things, and I'm focusing on renters, but they do survey people on how they're doing if they're in home ownership is their setting. And so this is really very good, and it's very current, timely data. And so the survey showed almost 9% of people, tenants, were not up to date on rent. And again, 37% unemployed, 50% showing a loss of income. When asked, how confident are you that you can pay the next month's rent? Only half reported high confidence in paying the next month's rent. And when asked about, are you worried about being evicted? Okay, about half were saying, I think it's likely or somewhat likely. So people are saying that right now, even though they can't be evicted for non-payment of rent right now. So it might be they don't know they can't be evicted, or they just know at some point evictions are going to open up and they're at risk. And so these numbers are, I thought the numbers would be high, but this really put kind of a fine point on how high they are. And then when you look at people of color, they're at more risk as well. You know, one of the things the state does is they do what's called a moving average, where they look, that's a statistical thing where you don't look at a snapshot in time, you look at a longer period of time, and you kind of average things out to see where they're at. And when we see here, we have an average unemployment rate for the last 6 months of 7.8. But for African Americans, you know, over twice that much, and over 3 times where they were sitting a year ago. Okay, and so for people of color, it looks like they're even more vulnerable to the economic effects of a pandemic and low employment and being a renter. So at the same time, I'm sorry to be kind of the bearer of bad news, but homelessness wasn't great here before the pandemic. I mean, we had record numbers here. People may be thinking about it more recently because they've seen tent cities and stuff, but that's, you know, that wasn't a change in the magnitude of homelessness. That was just in the change of the visual aspects of it. That just, you know, if you have a bunch of people in one place, you know, there are homeless people there. But if they're spread out throughout the community under bridges and behind trees and stuff, you don't see it. And that's just gone up in the pandemic. And county spending on homelessness has gone up a lot as well. The good news is we know from surveys and analysis that attorney representation of tenants in eviction defense leads to more favorable outcomes for the tenants, reduces the risk of homelessness, and reduces the need for county expenditure on homelessness. Not that that money has to go away, but that it comes down. So what are the estimates here? They're all over the board, and I think some of these are high. To say that we've got a chance of 75 to 95,000 of potential evictions in January in Minnesota seems high to me when, you know, before the pandemic, we were having 16,000 a year. But, you know, we got 38% unemployment. So what does that change? Hard to know. This study, this estimate was 281,000 tenants at risk in January, based on an assumption of a 30% renter unemployment rate. And we've got a 38% tenant unemployment rate. Still, you know, I have a hard time getting my head around that they could be that high. Maybe I'm just being kind of naive about it. But regardless of what it is, there's a limited capacity in the legal aid world. And when I was in legal aid, before I was a manager and I was just a staff attorney, you know, I was a pretty aggressive litigator. I liked going to court. I would go to court maybe 3 to 5 times a week on motion practice, kind of like a public defender, do a couple trials a month. I've probably done 250, 300 trials over my career. And I was on kind of the manic end of doing this. But still, if you had 15 of me doing 2 trials a month, that's still only, you know, 30 trials a month. And, you know, if you look at Hennepin County, you know, if you just took 10 times the pre-pandemic monthly amount, you'd have 5,000 eviction cases in Hennepin County, where they've got 15 attorneys doing legal aid work. You'd have 720 in Anoka, where they have I think they have 2 legal aid attorneys doing that work from 2 different programs. So it would completely kind of wipe out their capacity. And so what can people do if they're interested? Well, they can volunteer, they can donate. There are organizations doing policy work, and there are organizations doing direct representation. If you've never done mediation, maybe sign up to be a mediator through the mediation projects. Those are ways you can contribute. You don't have to be a genius about housing law to do this kind of work. Like any other area, the more you do it, the more you know. And so someone like me who's been doing it for a long time, I'm gonna spot more stuff. But part of my job is to train and mentor and consult and co-counsel with people. And you know, every day I'm talking to an attorney right now before evictions open up, helping them spot issues in cases and helping them figure out what they're going to do. The other thing you can do is you can be active as a citizen. You can advocate for policies that continue to protect tenants. You know, the governor didn't come up with Executive Order 2079 in a vacuum. It was because a number of us in the landlord-tenant community were saying, we need something here. The court system stopped evictions for about 2 weeks in mid-March from the Supreme Court, but then opened that up. And so then there were a bunch of us saying, Governor, you got to do something about this, because this is going to be really bad news to have people being homeless in a pandemic. And so he did. And the Attorney General's office has been doing really good work in enforcing those orders. When Keith Ellison was elected, I met with his staff over there, and I said, I think you need to have a housing unit to apply consumer law to the housing area. That was pre-pandemic, and they decided to do that. So they had some experience doing housing work before the executive order went into place, and they're doing good work. They've got maybe about 1,500 complaints of violations of Executive Order 2079 and its predecessor, and they call up the landlord and they investigate, and if the landlord's doing something wrong, they say knock it off. And for the most part, the landlord does, but they've charged out a few cases. And you know, I've got a list here of other folks in government that I think would be interested from hearing from people, both on the landlord and the tenant side, about how they feel that things are going on. And there's my contact information. And I'm happy to take questions and ramble more about other things.
Yeah, so I want to hit on some of the questions that kind of popped up. One of them that came up early on was when you talked about tenants causing harm. There was a question in regards to whether or not that's limited to causing harm to other people or property, or if that could include self-harm, if there's ideas of suicidal thoughts and actions.
That's interesting. I hadn't thought about that. I think if you read the executive order narrowly, I think the answer would be no, because I think the language, I've taken a look at it, but I think it was related to other residents. So if the word other is in there, then maybe not. If the word other isn't in there, then I would say yes.
Yeah, I guess I could see that. I think it sounds like it might be kind of difficult to show that there's suicidal thoughts or tendencies. I don't know.
Well, and of course, the other thing that you know, people can consider in that situation is contacting health authorities about that. There are processes to do guardianships and commitments. And I'm a guardian for an adult daughter with special needs. And so there are ways to engage other systems besides eviction that could help someone who's contemplating hurting themselves.
One of the questions kind of on the other side is, have any landlords or associations sued to invalidate the emergency order? If so, do you know how visible that suit is?
Yeah, there is a suit that is going right now, started in October, and it's in the motion to dismiss realm right now. So this is a suit against the governor by a couple of landlords, and the state has responded with a motion to dismiss that is calendared for early December. Similar cases around the country with other state executive orders have been unsuccessful. I think they all have been unsuccessful, but I could be wrong about that, but I'm pretty sure about it. And litigation against the governor so far with other executive orders has not been successful. So a little bit hard to kind of prognosticate this one. But you know, if I were to bet on it, I'd probably be betting with the state on it.
For folks who want to track that, is that, I'm just Googling around here, Heights Apartment and Walnut Trails, is that the
Yep,
case?
that's it.
And then another one that kind of came out is, and I think this is probably a really important one to pass on to clients and have this information readily and available. What should tenants do if they can't expect to pay rent?
Well, they should definitely contact the links that I had up in the slideshow, and you can find the slideshow on my website, and I'll put up a link to that in the chat. So they should definitely look for financial assistance. They should also engage the landlord right away and just say, I'm having trouble here, what, you know, and start working things out. And that's why lawyers volunteering with mediation programs could be really helpful in that effort. Part of what's, you know, good for tenants and bad for landlords in this pandemic is the eviction suspension has changed the power dynamic between landlords and tenants. You know, if a tenant was behind on the rent and wanted to say, can we work this out? The landlord was really holding most of the cards. Now, granted, the landlord would have to pay to file the eviction case, so there's a money cost to that. But if they were able and willing to front that cost, they really didn't have to bargain at all. Now, because they don't have the eviction remedy, I think they've been more reasonable, or not maybe they weren't being unreasonable before, but they have to negotiate more. And the results of those negotiations could be a reduction in the rent. It could be a payment plan. It could be allowing the tenant to move in another roommate, maybe more than the landlord had anticipated, so there's more income in the household. It could be letting the tenant out of the lease. And so maybe the tenant goes back and lives with mom or dad or lives with a relative. So there are a lot of things that can be done. I found landlords and tenants, for the most part, to be you know, reacting reasonably to what's going on right now. So very early on in the pandemic, you know, landlord tenant might say, yeah, I want to get out of the lease. And landlord says, okay, well, I want to start showing it. And tenant's thinking, well, thanks for letting me out of the lease, but I don't know if I want a lot of people traipsing through here while I'm getting ready to leave. And so when I would advise landlords and tenants about that, I'd say, well, maybe you can set up something virtual where, you know, the tenant, you know, goes out for a couple hours, the landlord comes in and does video of the apartment and then uses the video to show it and then cleans up afterwards. And so I found landlords and tenants, for the most part, being pretty creative about working things out. You know, you hear about slumlords now and then, but they're the exception to the rule. Most landlords are good folks. They're just trying to run a business, and for the most part, they want to keep their tenants because they get along with them and they have track records. Most tenants want to pay the rent. They don't want to be living out of a suitcase. And so you know, you hear about bad actors on both sides, and they kind of jade people about, well, all tenants are bad or all landlords are bad. You know, they're the exception. And so for tenants and landlords that are having trouble, it may sound kind of just a little inane just to say, well, talk to each other and see where things lead. Because I think a lot of good outcomes are happening out of those conversations right now.
Maybe I'll pitch that as a question to Tim Balland, who I see is asking some of the questions in the chat room too. And I don't want to speak on behalf or for Tim Balland, but I know he represents landlords. And
yeah,
thank you for the questions, Tim. So yeah, I'd be curious to know if that's also been your experience, Tim. We've got loads of questions coming in. Landon, do you want to I think you've been
Yeah.
tracking those a little closer than I have.
Yeah, moving kind of to one on the opposite side a little bit. How should a landlord respond when you have multiple tenants in a building and the tenants are essentially complaining about a bad act, complaining about a bad tenant? Obviously, the landlord can't evict them, but if their actions don't rise to the level of the executive order, what do you recommend that those landlords do in that situation?
Well, talk to the tenant and see if I mean, sometimes these things are gray. I mean, I've certainly had cases where the eviction complaint makes it look like it's a tenant from hell, and it turns out the person who's complaining about the tenant might be more problematic. That might be overly sensitive to sound, that wants no noise in the world. And if there's footsteps on the wood floor upstairs, then that tenant is being way too loud. So the first thing is to talk to the tenant and try to find out what the facts really are, and see if the tenant can mitigate their behavior if they need to, if the complaining tenant can kind of mitigate their sensitivities if they can. Ultimately, there's not a lot the landlord can do if they can't fit into the exceptions to the executive order. Now, there are other remedies out there that are not governed by the executive order. So, for instance, it seems to me that if you would fit one of these, you would fit the executive order as well. But if someone engages in harassment that violates the harassment law, then the question would be, well, if that is not serious endangerment, it still might be actionable as a harassment restraining order case. And that potentially could stop someone from engaging in harassing behavior that is not serious endangerment behavior. And harassment restraining orders can not only stop conduct, but they can preclude people from being in certain spaces, which could include an apartment building. But I would say those are probably going to be pretty rare cases. And so the question for the landlord is, can you fit within the exceptions of the executive order? And if you can't, eviction's not going to be a remedy.
And this seems like a quick one, but can an HRO be used to evict a tenant? It seems like if you got an HRO, you probably hit the level of the executive order.
You can. It depends. So with HROs, and I've done this kind of practice. I've done family law in the past and harassment restraining order work on both sides. Okay, it's always going to be the least restrictive remedy that solves the problem that the court's going to use. So, for instance, if I'm calling you up and swearing at you, then maybe the result is I don't call you up and swear at you anymore. And because that's less restrictive than limiting my movement in the world. Okay, if we're in the same apartment building and I'm swearing at you in the elevator, then maybe the result is if I see you, I go the other way, that I have to stay a certain distance from you. But if those types of narrower restrictions don't work, I have heard of cases where it's like, you have to be a quarter mile away from the person you're harassing. And if you're in the same apartment building, that would mean you don't live in that apartment building anymore. I think in a pandemic, a judge or referee would probably be disinclined to go down that road unless it was a pretty extreme situation, but it's certainly plausible.
One of the questions I think is kind of interesting. It kind of connects to what we're talking about, but it has a different take on it. You talked about the rate of homelessness, and recently in the Star Tribune, they had talked about essentially people who were previously transient and were now living in hotels for quite a period of time, a couple months, I believe now. And their rent is essentially being paid for by a third party, whether government or a nonprofit organization. In those situations, did those individuals, do the renters who you know, the rent is being paid by a government or third party. Do those people have the same landlord-tenant rights that we're dealing with in regards to what would typically be a long-term contract?
Well, then that really gets you at the statutory definition of who's a tenant and who isn't. And the statutory definition roughly is if money is being paid or services provided for occupancy, you're a tenant. Okay. Now, some people read that narrowly to say, well, it has to be the person who's paying that rent, but I don't read the statute that narrowly. So like if my brother is paying my rent at a long-term hotel, then I'm in a landlord-tenant relationship with that hotel. It sometimes can get a little more complicated than that, but that's generally the question. If money is changing hands or services are being provided, like a caretaker, in exchange for occupancy, then you are in a landlord-tenant situation. And so like in Section 8, for instance, when someone has a Section 8 voucher, if that person had no income, then Section 8 would be paying the entire rent for that person. That person is still a tenant.
Great. And I do apologize. I mentioned this early on. Unfortunately, I have to drop off, but I do want to take the time to just say thanks to both Mike and Larry. I really appreciate the conversations. It's always interesting. And I will let you guys continue the conversation.
Thanks, Landon. Thanks so much. There are a number of other questions in the chat and the Q&A. Jeffrey's asking about how far out does family member go from landlord? Is a niece a family member? I assume that's a question about the exception in the administrative order. I was also wondering what situation is that meant to accommodate exactly?
Well, I think it was meant to accommodate kind of the flip side of what I was just talking about when I was saying, well, maybe the tenant says, well, let me out of the lease so I can go live with mom and dad. And so I think this was meant to accommodate the landlords who maybe had kids coming back and wanted to be able to put them in one of their units. I wasn't involved in the lobbying for that. And so I'm not sure what the factual basis for that was, but that would be my speculation. I'd have to take a quick look at the executive order to see what the language is on that. And so I'm gonna do that while we're talking. So it's Executive Order 2079, and I'm gonna pull it up here and take a quick look at what exactly it said about family member. My recollection is that it didn't have a lot of flesh on the bone about that. And so let's see what I've got here. Okay, so yeah, it says due to the need to move the property owner or property owner's family member into the property. I don't know if we're gonna have to engage family law people to talk about how you would define the word family member. I have been thinking about it as immediate family myself. So I've been thinking mom or dad, son or daughter, maybe brother or sister. I think getting out to, nieces and cousins and stuff, I'd be a little surprised, but it's great. And ultimately, the Attorney General's office would have to make a decision on, are we considering this a violation of the order? Because they're the ones that have the authority to enforce it. Although as I read the executive order, I think tenants could enforce it too, because there is a reference in the executive order to the Attorney General's powers under statute 8.31. I think there is in there. Yeah, and under 8.31, there is a private right of action section to for individuals to step into the shoes of the Attorney General to litigate things that are governed by 8.31. But my best guess would be that courts would look a little bit narrowly at who's a family member to probably an immediate family. So I'm thinking mom, dad, son, daughter, maybe brother, sister.
You said you haven't seen much activity or at least litigation around this piece of it. Is that because it's not being litigated or present, or is it possible that that's going on and we're just not aware of it?
Well, we know what's going on, and it's a newer exception to the eviction suspension. The eviction suspension started on March 24, and this exception was not in it. And this exception only showed up with 2079, which is the successor to 2 earlier eviction executive orders. So that came into effect on August 4. So it hasn't been around that long. It's only been around about 3 months. I have heard of notices being given. Again, the problem for the tenant is assessing, is this bogus or not, right? Because a tenant's having to assess at the point when the landlord's saying leave, what's going to happen 7 days after I leave. And only if the landlord did not move in an appropriate person 7 days later would the tenant know that maybe this was a farce. And so then what right does a tenant have at that point to sue over it? And what is the action that the tenant would do? I mean, maybe the tenant could say, well, I'm still a tenant because you didn't do this right, but you've already relinquished possession of the property and moved out. And so have you abandoned the tenancy? And so I think the challenge here is, I think we're not seeing a lot of litigation there because the tenant's having to make, one would argue, kind of a premature decision with insufficient knowledge of the facts to determine whether they ought to move or not. And a lot of tenants don't want to get evictions on their record because those evictions can follow them around. So the notices are happening. I haven't seen any court decisions on the propriety of that cause of action.
I was wondering if there's a remedy. I mean, I assume that you file a complaint with the Attorney General's office. That's a possible thing, but you know, what would the remedy even be?
Yeah, I mean, and that's what you could do. And but the other thing is, you know, once you're, you know, 7 days out and you've moved all your stuff, maybe your incentive to really go after it at that point is low. So it's a very odd exception, and it's kind of a very odd cause of action because the cause of action is premised on a future event. Now it's premised on the landlord saying, I'm going to do this future event, and the landlord might be totally legit about it. But in terms of analyzing the legitimacy of it, you're having to analyze it based on a future event.
I've got loads of questions. I think what I'm going to do, Lawrence, is if it's all right with you, we've got more questions and I'm going to be able to forward on to you right at this time. I wonder if I might collect some of these, send them over to you, and then post them in the communities, or I can follow up with an email to all of the attendees as well, with the CLE code, with the slides if they're available, and other information as it's gathered here. Thanks for posting that in. But before we end, let me just grab a couple of questions that have been in the queue longer than the others. There's an anonymous question from an anonymous attendee. Says, I have a client whose redemption period for the mortgage foreclosure ended in February before the executive order came into effect. The new owner of the home who purchased the house from the mortgage company is threatening to evict. How do you think the executive order affects this situation?
Just whether they fit the exceptions or not. I mean, I saw a mortgage foreclosure, a post-mortgage foreclosure case a couple of weeks ago and consulted on it. Pretty weird case. So this was the post-redemption owner about 6 months later filing an eviction case but tried to fit it within the exceptions, arguing that there was significant damage and substantial endangerment. I think those claims in that case were kind of marginal, but that's what one would have to do in any kind of case right now, regardless of how the relationship originated, is whether it fits in the exception. So simply, so the new owner there would have to not just say, I want to rent to someone else, or I want, now the new owner could say, I want to live there, right? And that would fit the exception of wanting to move myself or a family member on. But if what if the new owner wants to do is have someone in there who can maybe pay a higher amount, unless they can show one of the exceptions like substantial endangerment or significant property damage and fit all the parameters of that, they're not going to be able to do it. And I don't want to be cavalier about this. I mean, I do tenant advocacy, but I'm not cavalier about the fact that this is a hardship on property owners. And all I can say about that is this is the world in which we live at the moment. And so you make your choices and you make you have your options and your negotiation points based on what are realistic outcomes. That's what we do as attorneys all the time, is we advise people on, this outcome that you want is not attainable right now. Here are some alternative outcomes. Here are some negotiation strategies, and let's roll up our sleeves and do the best we can.
I had an opportunity just to briefly scan that Aspen study that you referenced in the slides. It is interesting. They made a reasoned argument for the landlords and talked about the risks there as well. It was interesting. Interesting read. I can include that in the materials as well that I send out to everyone. Folks are asking for the CLE code. My apologies, I don't have it here, but because we've got so many questions and materials and references, I think what I'll do is follow up with an email to everyone with the course code, the materials, and some of the questions that we didn't get a chance to answer. So I'll forward those over to Lawrence as well. Maybe one quick final question from the Q&A. It says from Megan, if there is time, yes, Megan, we have one last minute. Do you believe that the changed nature of services provided to traditional daily shelter residents to longer-term hotel stays changes the responsibilities of the agencies providing services?
Yeah, I mean, kind of a misconception in hotels and shelters and landlord-tenant law is the length of stay is determinative of the relationship. And I would say that's incorrect. I could be a tenant for a week, or I could be a guest for a week, or I could be a tenant for a year, or I could be a guest for a year. So the question really has to do with what is the relationship, not the tenure of it. Now, when you're looking at hotels and shelters, we do have a hotel motel law that talks about what are the rights of the owner to remove someone. And essentially what it does, it makes a distinction based on, is this your principal place of residence or not? Do you have a residence elsewhere? If you don't have a residence elsewhere, the presumption is that you are residing here and that you're a tenant. If you have a residence elsewhere, the presumption is that you're a guest and not a tenant. So the distinction would be, if I go to Chicago to watch a Bears game and I stay in a hotel and I got a house here and I act up, I don't pay my bill, or I'm wrecking the room or something, they can toss me. They can have the police come and say, McDonough, you're out of here because you're now a trespasser, okay? Now, let's say I don't live in this house anymore, and I'm now staying in a hotel shelter, and I've been there for a week or a month or so, and I'm paying for that shelter stay. Under Minnesota law, the presumption would be that I'm a tenant and I'm not a guest, which means that the shelter is going to have to follow landlord-tenant law and how it deals with me. So the distinction really is, am I a guest or am I a tenant? And tenure doesn't make that distinction. It's more about, what the actual relationship is and whether I have a residency elsewhere.
Be a fact-based situation if you're an Airbnb host, I imagine, where that person could be your guest because they are transitioning from another housing situation, or they could be visiting for the Bears game, as you say. It was,
Yeah. Now, if the whole thing with Airbnb, and I haven't researched it a lot, is, do they really fit the hotel paradigm, or do they fit kind of the short-term rental, short-term landlord paradigm? And I haven't researched whether there are cases delineating that out. And so, but yeah, but if they are in the hotel paradigm, and I don't have a residence elsewhere, they may be taking on a landlord-tenant relationship. But they also might be taking that on because they might be regulated by municipal codes saying, if you are going to be Airbnb, we are treating you like a landlord and you got to be licensed. And by that action, maybe defining it as a landlord-tenant relationship, regardless of whether I have a residence elsewhere or not.
interesting. I hate to cut this off. We are well past our time. Thank you so much. And to everyone attending, I'll grab the chat transcript. I'll make sure that any question we did not get to, we have an opportunity to answer. Just give me a day or two to get that stuff organized. I'll also provide the materials, the CLE code. And I also just want to make sure that everybody who's attending has an idea for what the next step is. So that final slide on Lawrence's slide presentation, I just want to make sure that everybody's got access to that so that they can be prepared to help when help is needed. So thank you everyone for joining. Thank you, Lawrence, again. Great presentation. So glad to have this conversation. And I hope everyone has a great rest of your day on this beautiful fallish day in Minnesota.
Yeah, and I'm happy to come back, and it might make sense to do another one of these closer to the end of the year. We'll have a little better sense as to whether things are in a different place in mid-December than they are now. So, but whatever works, I'd be happy to come back and talk more.
Yeah, we've got plenty to talk about, so be very glad to have you back. Thanks to everyone for joining. Have a great day.